Thank you, Zoran. Okay, finally putting my own presentation on it. As Zoran announced, I'm going to talk about the updating a century-old convention. So after 2 days speaking about the Hague rules, a very old one, today we're going to talk about even older convention, the very first one adopted by the CMI together with the old Salvage Convention in 1910. So this is the first convention, the first convention list that we're going to talk about. It was ratified or heard by 84 states, so we can say it was quite well received. However, in 2022, Italian Maritime Law Association actually gave an initiative to the CMI to rethink or to assess whether this convention needs to be modernized, together with the second convention on concerning civil jurisdiction in matters of collision. And the CMI actually set up an international working group. That meant that this working group also had to look into the Rio Draft Convention and into the Lisbon rules, and also to look at the EU law, because some issues like enforcement and recognition, as well as the choice of law, are regulated by EU law, and EU has exclusive competences in certain fields. So I will share with you some recent developments in the work of the International Working Group, which I joined later on after the Göteborg assembly in 2024. So I was not there from its beginning, but at the beginning, the International Working Group actually did a questionnaire, created a questionnaire, and distributed this questionnaire to the national maritime law associations in order to see whether national law associations think that some provisions or all provisions should be changed, and whether the amendments are needed, or maybe a new convention should be adopted. 23 national reports were received, plus the International Chamber of Shipping and the sector of insurers, and responses were very divergent. So there was a full range of those responses, a number of those who were, of course, in favor, number of those who were opposed, because they were afraid that adopting amendments would actually lead not to unification, but to parallel systems, so opposite than what is actually the goal of the international conventions. Such a position, so opposing to the amendments, or very cautious in respect the question of amendment convention, was also raised by many members of the working group. However, we went through all the questions, and at the beginning we detected, or they detected, because I joined later, they detected two groups of questions. The first was not so hard questions, and the hard questions were first hard questions and then not so hard questions. Hard questions were those where the answers of the national maritime law associations and the insurance and shipping sectors were so opposing. And those not so hard were those where at least not a consensus existed, but not so diametrically opposed opinions were given. So not so hard questions were the definition, the scope of application, questions in respect of liability, not all, some of them are difficult ones, international private law, jurisdiction and recognition and enforcement. And the hard questions were the channeling of liability, the need for compulsory insurance and direct action, the need of introduction of the concept of strict or fault-based or joint and several liability to third parties for damage or injury caused by the collision to person and property on board. And the fourth question, the same, but to persons and property that were not on board. And the last one was the question of mass, whether we have to include it or maybe it's already this convention broad enough to encompass the mass. The group started with hard questions. However, in the Göteborg meeting, it was clear that we will not have a consensus on those questions. So it was decided to park aside those questions and to start with those that were not so hard questions. And we also decided to continue to accelerate the work and to work online. So we had every 2 months online meetings to discuss different questions. And on this way, we also reopened hard questions. After the Tokyo Assembly, the decision was brought that we will meet once a month. So it's quite a dynamic working group with many members that are really active. So I really benefited a lot, at least from hearing all these arguments pro and contra. So I will now share, and those hard questions were put aside, as I said, in Göteborg, but then reopened, and surprisingly, or maybe not, actually we managed to agree on the first, second, and the fourth question. And I'm going to show you what was the conclusion in respect of those hard questions. So I will start with mandatory insurance and direct action. And I will try to show you the arguments that were put forward from the proponents and for the from opponents of the introduction of mandatory insurance and direct action. So this is the second one. No. Okay, I think I missed one slide, but it doesn't matter. So the proponent said that the introduction of mandatory insurance and direct action is actually something that already works at the international scene, that it is a concept that works and that it should be introduced into the Collision Convention as well, that it is a modern trend, let's say so. The opponent said, yes, it is true that it is functioning, but only for some conventions like pollution convention, where there is a public interest, and it should not be, the parallel should not be drawn with this convention, which is purely private one. Then they said that the current system works well, so that there is no need to actually fix something that's not broken. And if it works well, then there is no compelling need to change it. And so we're really against that. From those proponents, the question was raised as a contra-argument. You said it's not public policy, but who is the one that is determining who is the public, what is the public policy and what should be actually in public interest? And this is the question that actually Petar Grgić brought out 2 years ago, because they said it is unfair that the person who suffers damage due to the pollution has a right to direct action, and on the other hand, that the person who suffers damage due to the collision doesn't have the right to direct action. So it's not a question of the public interest, it is an interest of that damaged party. Then as a counter-argument, those who were opposed to the introduction of the mandatory insurance said, okay, but who are actually those victims that we want to protect by this direct action and mandatory insurance? Because passengers, we already have the Athens Convention with compulsory insurance and right of direct action. In respect of crew members, there is also the convention providing compulsory insurance or recommending compulsory insurance. And actually, it's only the cargo which is uninsured. So do you really think that we should propose mandatory insurance and direct action, so to burden the ship with mandatory insurance, because in order to protect the cargo that was uninsured, and that was a commercial decision of the cargo not to be insured. So here we had really strong counter-argument for that. And then we can come to this slide. I don't know when all of this was on the one that disappeared. So the next point brought out by the opponents was that there are serious practical obstacles to issue the certificates of guarantee because of the way that the insurance for the collision damages works. As you all know, it's divided through one part is covered by the Holland machinery and the other part by the B&I clubs, and the Holland machinery functions is provided on the prescription basis. So you have sometimes, you saw on the Adriana's case, but sometimes you have 20 underwriters, and they said that it would be really difficult to issue one certificate covering all the liability, and that there is no chance that one underwriter or leading insurer would give such a guarantee. The others then gave counter-argument, and they said that's not really true, because there are already mechanisms in place. So it was shown in the practice that it's possible to obtain such certificates of guarantees, but that was a full stop. Then another argument pro was that direct action would provide greater protection for victims. That's something that I already said before. But the contra-argument that I did not mention before is that those opposing to its introduction said that this may lead actually to further complications in the procedure, because the claimants would have to sue in different jurisdictions, claims brought against different insurers. So it would be rather complex than the easy way as it was supposed to be. And then finally, and maybe the strongest argument that led to the conclusion was that the introduction of those instruments could have a deterrent effect on the ratification of this protocol. Many national law associations were against, shipping industry was against, and insurance sector were against. So at the end, even though there were some members of the working group who are really in favor of this, the conclusion of the working group, anonymous, was that there is no compelling need for mandatory insurance or their action, and therefore it will not be included in the draft protocol. I have to say here, I said anonymous. However, we did not have a single meeting where all the members of the working group were present. However, minutes are sent each time, so whoever wanted to react or reopen the question could have done so, and no one of the members of the group did so. Okay, then we have channeling of liability. That was the question that was actually very closely connected to mandatory insurance and direct action. However, it was repeated several times by some members of the working group that it is a standalone instrument. And we all agreed that introducing the channeling of liability would be advantage for victims, because they would easily identify the person against whom compensation claims may be brought. And that was a general agreement. However, that does not mean that the procedure is simplified, because we don't have strict liability. This is one of the points that we were all in line, that we will not introduce strict liability. So full-based liability remains. And if you have the full-based liability, then the fault has to be proven. And then if you have to prove the fault, the question is, where is the justification to have a person whose negligence was proven, and to actually direct your claim against the ship owner? So you have the one who did act or did not omitted to act, and then is it actually fair? And the question was, who are the individuals that we want to protect by this channeling of liability? And those who were proponents of this idea actually proposed a really long list of persons to be covered, from, of course, crew members and agents and servants, then also charterers, all charterers, including bareboat charter, managers, then operators of the vessel, and also persons conducting salvage. So a really, really broad list. It was quite a long discussion. We went person by person, and we concluded that the owner's employees are already protected by Carriage liability of the owner, and that the pilots are also already included because they are explicitly mentioned in the convention. And we decided that there is no compelling need to protect all those other persons listed into that list. And then the arguments they had was, well, maybe we should introduce the protection for those persons, because in that case, those persons will not have to have the insurance coverage for the case of the collision. However, the question then was raised, but shouldn't the owner have the right to recourse against those persons who are at fault? So we were building arguments pro and contra, and we concluded that channeling of liability is mainly associated with strict liability, and as we said, we are going to maintain the full-face liability, and with compulsory insurance and the right of direct action, which we decided not to include. So the group decided actually that there is no compelling need for channeling of liability, and that it will not be included into the draft. It is actually the same reason that, as mentioned in the mandatory insurance and direct action, the introduction of channeling liability could be the reason for states not to ratify such a protocol. So we decided not to include this into the draft. The third question that we also voted on was the need to regulate the damage or injury to third parties on board. The question was whether to introduce joint and several liability toward those parties. And of course, the main argument pro was the protection of third innocent parties. However, it was noted that this might be detrimental because of the 2 years time bar in the convention, while some national laws may provide a longer time bar. And we also noted that it could be problematic in respect of cargo carried on board the other ship, because by introducing such right, it could bypass the defense of error in navigation contained in bill of lading. We agree that it's not problematic in respect of damages to the third parties, for example, ships or bridge or port facilities and so on. But those cases are so rare and actually regulated by the national law, and we decided that there is no compelling need to uniform this question. So yeah, and another reason against this was that such right could lead to attempts to circumvent the rules on limitation of liability, because the injured party, the victim, would probably choose to claim against the bigger vessel or the vessel that has a bigger fund of liability. So the conclusion again was that there is no compelling need and that it will not be included into the draft protocol. And before thanking you for your attention, I said that those questions were hard questions, even though it may not seem now that they are hard, it may seem that it's logical that we decided not to include them into. So we may say that we resolved many hard questions. However, the hard work is in front of us because now we have to work on those not so hard questions and work on the drafting of those provisions, which is not hard question, but hard job and hard. Okay, now thank you for your attention.